Good morning. This is the Energy and Carbon Management Commission. It is Tuesday the 15th. It's 9 a.m. and we will start with a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
and Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Great. Welcome, everybody. This is a continuation of docket 240600145, the cumulative impacts and enhanced systems and practices rulemaking. We last convened, I think it was last Thursday, and we had a few days of commissioners providing a direction to staff. Yesterday at about 1 o'clock, the red line with those directions was filed, and all of our parties received copies of those filings. And this morning, we are going to review those documents with staff and see where we're at. So with that, I would like to recognize Assistant Attorney General Caitlin Stafford for any preliminary comments on the filings that were made yesterday.
Thank you, Chair Robbins, and good morning, commissioners and stakeholders. So I am here to briefly walk through some additional changes you may have all seen appear in the draft that might look a little bit different from at least commissioner direction, but were necessary based on some other edits that we were making based on commissioner direction. So I'm not sure if it is helpful for me to share the red line and walk through that, or if I should just walk through the changes. I'm not sure what the commissioners prefer. If you'd like to let me know.
It probably depends upon the extensiveness of changes. So I'm going to defer to your discretion in terms of what might be the best way to broach this topic to us.
Okay, thank you. I think it might make sense to share my screen just so that you can easily see some of these additional adjustments. So if you'll bear with me for a second here. And then just to ensure we're in the document, the compare document that was uploaded with the red lines and purple lines that everyone received yesterday. So to start off, in the 100 series, we had to make some additional changes related to our incorporation by reference definitions because of the timing of the vote. The earliest date these rules can go into effect is now December 15th, 2024. And so as you'll see throughout and anytime we incorporated a definition by reference or incorporated a standard rule or guideline by reference, we are ensuring that that is static, set at the date that these rules will go into effect, as has been our practice for the past multiple rulemakings, at least. Bringing you down further into the rules, we were given direction to standardize references to building units, high occupancy building units, to ensure that there were, I guess, no buildings that were left out where we needed to be looking at something of that nature. So I will bring you down to the first place where this rule change, or at least this edit, occurs. And that is down here in one of our notice requirements. And so what we did is we were editing the rules as we looked at all the different building unit, residential building unit, school facility, high occupancy building unit, child care center definitions to figure out where overlap was and basically what the intent of the rules we were dealing with, what they were trying to get at. And it became pretty clear that, at least when we were referencing building unit and high occupancy building unit, which I should say any reference to building unit includes a residential building unit. Any reference to a high occupancy building unit includes schools and childcare centers. So staff made some edits there to ensure that where we were talking about people, notice to people, trying to reach people, that we were using at least the building unit and high occupancy building unit references there, again, to ensure that we were reaching people. Where we were thinking about different informational requirements related to the location of proposed operations and things like that, it made sense from our perspective to use that longer list that appears elsewhere in the rules and some of our informational requirements related to residential building unit, high occupancy building unit, school facility, and child care center, where something has to do with analyzing the location and different boundaries. That definition of school facility is a little bit broader. The boundaries are a little bit more extensive than just school. So if you're looking through, you'll see various changes to different rules along those lines. I'm happy to walk through those a little bit more in depth, or if you have additional changes or suggestions that you would like to see there, please obviously let us know. There were also some new rule references that needed to be updated. Specifically, as you all saw, we made an edit to 306, the director's recommendation to bring in the timing language as directed by the commission. Because of our addition there to make that D, we had to move existing D to E, and we've changed the reference throughout the rules where that appears. And that I don't believe that necessitated bringing in a current rule that we had not changed before, but there were some citations changed there to ensure that we were referencing the correct rule number. The next change that might appear a little differently is a change related to a misnumbering. Give me a second here. I will find it in this other document that I'm looking at where my notes are, so that I can direct you all to it in the current document that we're looking at. This was simply a misnumbering. It appeared in your prior version as a subpart L. It should have been subpart M. And so we made that change. And then there were a couple of rules that were brought in because we had to, again, change a citation that occurred most notably, at least to me, in Rule 309 F. F1, or excuse me, sorry, trying to find my spot here. I'm sorry, it occurred in 309E related to the consultation with CPW. As you'll see, this rule was not originally in some of our drafts, but because of a citation change, we had to make that citation change right here. Bringing us down into the cumulative impacts analysis. I'm sorry if my scrolling is giving anyone any issues here. We had a suggested, as we were looking at how different analyses and plans, the language that we use when we are asking for those, it occurred to us, this change right here, perform to submit. We typically ask for that something be submitted, not that it just be performed. And so we made that edit there just to clarify. That was our intent to make that edit, I think, a couple of drafts ago, and it unfortunately did not carry over. Moving into Rule 316, we had, I'm sorry, I thought I got there. Rule 316C. In C1B here, this, I reworded this ever so slightly just to improve readability. If you are looking at this and you are unclear if this improves readability or if there is an additional change to be made, please let me know, but that was the intent there. There was another change, or at least a suggested change that I had in Rule 316 sorry. 316C4. I did not make this change, but because of the structure of this rule, how things are worded, this language is fit if you are so inclined. I was just told my connection isn't stable, so I will take my video off, and I apologize.
So can you restate the point you're trying to make there, Ms. Stafford, because we missed it?
Sure. So in the introduction to this subpart of the rule, we talk about all new oil and gas locations subject to this rule. And the subpart below basically repeats new oil and gas locations. So it was my suggestion that we could potentially strike that if you are so inclined. In that provision.
That makes sense. I think that's redundant, repetitive, whatever you want to call it.
Okay, I will, at least for now, I'll just highlight it just to keep going. There was also a change in this subpart D here in little e. This originally said ozone season. We don't talk about ozone season in the rules. We talk about the May 1st to September 30th time period. So that adjustment was also made there. And then in Rule 604B4, I guess what is proposed to be Rule 604B4 A Romanet 4. So as you are aware, the black language that is in front of you, this is what is current Rule 604. The structure of the rule has now changed based on some of the renumbering, but this language here, or an alternative location analysis performed for the RLG, this appears in the current rule. It was, I think, in some prior version was deleted because staff had originally suggested that the ALA current rule references be deleted or reorganized in one of our prior drafts, since the commission has decided not to change Rule 304. Current Rule 304B2 only makes some minor adjustments to ensure that the proper distances are in the rule. I wanted to flag that because this is the current rule. I wasn't sure if we should keep this here, this reference to substantial equivalence. This also references to 304E, where we also accept an ALA that is the director has accepted as substantially equivalent. So this is more of a flag for you all that this is current rule language, and if you would like to keep it in 604, wanted to make sure that was on, you were aware of that as well. And then as we scroll into the new proposal for subpart B, there is a reference here in little ff. This piece talks about the community liaison providing assistance. We do have language in 224 now that talks about the community benefit agreement. I think there was a thought from staff here that this might be unnecessary, sort of based on how it was incorporated in 224. So again, wanted to flag that as maybe a potential change here. And then I have one final thing. In 1201, we had proposed to change this citation originally because, again, we were removing some of staff had initially proposed to remove the ALA some of those ALA requirements as they appear in current rules, because due to our original proposal in the first draft that was sent out. But because of the fact that this ALA language will be retained, this citation change doesn't need to be made anymore. So we don't actually need to make a change to this rule. So I left it here, but it would be, I think, staff's suggestion that we can remove this change because the reference does not need to be changed anymore.
Okay. Let me ask a few qualifying questions. Or so you do not think this change in 1201 needs to be made? Is that right?
I do not, and you'll see the red change that I suggested is basically citing back to the same thing that we have in current rule now.
Okay, and then if we could go back to the ALA language.
I'm sorry, in 304?
I don't know, it's wherever you were referring to some ALA language change or not change.
Well, actually, yes, that was in 604. I apologize. It's right here, this highlight.
Okay, and explain that again.
So this is current rule language. This is current rule 604 B4. This text appears in the current rule language, and in the draft 604 that we were asked to incorporate, it had fallen out of that draft. I think that was due to some previous suggestions by staff that the ALA process be significantly reorganized. Our initial proposal was that, there was an ALA for each location. So that language does, this language currently appears in rule. I wanted to flag it to ensure that you had the opportunity to consider whether it still belongs here as part of the changes to 604 or whether it should be removed as it was in the draft 604 that we were given.
So this is current language in our rules that was stricken, and you're suggesting potentially reinserting it.
That is our question. If the commission feels that it needs to be kept as is or reinserted.
And it allows for the alternative location analysis that is deemed substantially equivalent by the director that was done for a relevant local government to be operable.
That is my understanding.
Okay. It's at the director's discretion, so I don't necessarily have a concern to give the director the discretion to allow for an ALA performed for a relevant local government to be operable at a time or not. It's up to the director. I guess I'm one commissioner and I can't see anybody else because all I can see is your screens. I don't know what other folks are thinking.
So I mean, I would agree. We've already got language in the ALA section of the 300 series rules that indicates that we 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 may accept a relevant local government's ALA as substantially equivalent information. So I don't know why we wouldn't also allow that in Rule 604. It's the same thing. I don't even know if they're. I mean, I have no problem with this change because we've already acknowledged in the 300 series that substantially equivalent ALAs can be utilized. So.
Right. Others with thoughts? I'm seeing nodding of heads in the positive direction. Are we good with that? Okay, and then the cumulative, or I'm sorry, the liaison language that you flagged, Ms. Stafford, as long as that language is found within 224, I don't have a problem not repeating it. And I guess I'm relying upon your affirmation that 224 covers it in terms of the community benefits agreement piece.
I would say that Rule 224 is not as specific as this particular language. So I just wanted to bring it up to ensure.
Let me ask the question in an alternative fashion. If we leave the language in place at 604, is there any harm caused?
I don't believe so, no.
Then I would suggest we leave it in place. That was a fairly discussed point with various stakeholders. And as long as it's not creating any harm, I don't have a problem with any potential duplication. That's just one commissioner's thoughts. Others? Commissioner Ackerman, you're nodding up and down. You're good. So we'll leave the liaison language at 604, despite the fact that there may be some duplication.
Understood. Thank you.
I had two minor nits or picks. I had suggested when I put forward the Rule 604, two SBP edits. You don't need to share your screen, Ms. Stafford. One is that the alternative location analysis required at Rule 604B4B Romanet 1 would be applied in the same manner as the ALA at 304B2. I didn't see that SBP language got inserted, so I would request that be amended. And then the second was that the SBP doesn't indicate that 604B4B1 would be and 2 would be applied at the same time. So that's that kind of you got to qualify to get in on 604 for the robust substantial equivalence. And then you also have to make a finding. All of that needs to take place at one hearing. I just wanted to clarify that in the SBP as well. Those were 2 points that I had made when I introduced those concepts. Didn't see that they made them into the SBP, sort of fine-tooth, but I think important. So if those could be made, and then generally, once we get to when we're voting, kind of a fine tooth looking through and making sure that we don't have any additional typos. But that's how we generally do rulemaking. So with that, Ms. Stafford, are you through with the suggested conforming edits that you've made?
Thank you, Chair. That was all I had on my list.
Okay, well, we really appreciate it. I know this has been a Herculean task, and I hope that you get a chance to take some time because you and your staff have done an amazing job. Commissioners, at this point, we have before us the red lines, the rules, the comporting edits, and et cetera. Were there other concerns, thoughts from commissioners about the draft that we have in place at this point? Commissioner Ackerman?
Thanks, Mr. Chair. Like you, I appreciate the work that's been done. And like you, I just have 2 brief discussion items, potentially suggestions or just clarifications. And the first one, and I don't think you need to pull up the document on this one either, Ms. Stafford, but On the community liaisons, we had some language in there that says neither the commission nor the director may direct the community liaison to take any specific position on a substantive issue within the community liaison's duties. And I had suggested a change that that's not just limited to the commissioner director may not direct the community liaison to do that, but simply that the community liaison may just not do that. I see that that change wasn't made and wanted to just check to see if that was deliberate, or if not, I would suggest that we clarify that change.
AG Stafford?
Thank you, Chair. I do not recall receiving specific direction on that particular change, though I could be misremembering that point. So if I can make the change right now if that is the commission's preference.
I don't believe it was our intent for the community liaison to be able to take a specific position on a substantive issue.
Everybody good with the suggestion from Commissioner Ackerman? Then yes, Ms. Stafford, we'd like that change to be made.
And if I might just briefly, Commissioner Ackerman, was there a specific way that you were envisioning this worded?
Thank you. Let me get back there real quick. And to me, it would be pretty simplifying to just say, instead of saying neither the commissioner or the director may direct, I think it would just be simple to say the community liaison may not take any specific position on a substantive issue within the community liaison's duties.
Okay, so what I have here now is subpart D, the community liaison may not take any specific position on a substantive issue within the community liaison's duties.
So I may make a suggestion. I don't disagree, Commissioner Ackerman, with that you had brought that point up, and I think we agreed to not have the community liaison take a specific position. But I do think because of the input that was provided by stakeholders on this one in particular, it's important to also include the director and the commission directing in addition to the community liaison taking a position, just to be clear on the point. So it's capturing everything, right? And I think your intent is for it to capture everything, but I think it needs to just be explicit.
And no objection.
Did you get that, Ms. Stafford?
You could, I guess, repeat the direction there. That would be helpful.
I think it's and both.
Yeah, to me, I think you could, it might be a little awkward, but you could leave the sentence as it reads and then add an additional sentence that also states that the community liaison may not independently take a substantive issue, or may not take a specific position on a substantive issue. Or if you can artfully include it in that same sentence, I'm fine with that as well.
Anything else, Commissioner Ackerman?
I just had one more, and this is in Regulation 904, predictably, and appreciate staff's additional consideration and the additional language there. Remember that there was just language that identified this is the director's annual report, and there was language initially that just identified that we would include information regarding reclamation, and specified just wells that had received final reclamation that year. And I asked for a broader inclusory language there to be able to include further reclamation details in the director's report. And we added the clause and information regarding interim reclamation inspections that occurred pursuant to Rule 1003. And I have the same concern. Again, I don't want to reopen this issue if the rest of the commission feels like this is the appropriate place to land. Again, I feel like we're just regulating ourselves here, and I think we could strike the words inspections that occurred, leaving it and information regarding interim reclamation pursuant to Rule 1003, which gives us discretion to include certainly information about inspections that occurred, but we're also looking for whatever information that's available that we may have that we could also include. So I'd rather be inclusive there and don't see a reason to be exclusionary, since again, I'd rather include what we can include and not have an argument that we shouldn't.
I would agree with that.
Any naysayers? Capture that, Ms. Stafford.
Thank you. Just to confirm, I am striking inspections that occurred.
Yep, just those 3 words, and I think that'll do it for us. And just a note that would also include in the statement of basis and purpose explanatory paragraph, just striking the very last word under Rule 904, which is inspections. And I think that would get us there. And that's all I have, Mr. Chair. Thank you.
Any other thoughts, questions, concerns from other commissioners with regard to drafts as presented yesterday? Commissioner Cross and then Commissioner Messner.
Thank you, Mr. Chair, and thank you again for the hard work on this. I wanted to note one nit. I don't know if we want to go through it later, but I did note one nit on the penultimate page there, page 55, the footnote 3 on 604 says avoid, minimize, and minimize. And it should be avoid, minimize, and mitigate.
Yeah, yeah, appreciate that. And that falls into sort of the general typographical error read through one last time that staff will do, but appreciate you calling it out.
And then I just wanted to also clarify on that part of it. And I think, Mr. Chair, I think the discussion that you had was similar points that I wanted to raise on the 604. But as it currently reads in the body of the SBP, it talks about says new rule 604 B4 B1 provides that the commission will not make a finding of substantial equivalence unless the operator demonstrates, and then it has the points below that, and it talks about specifically alternative location analysis as required by 604 B4A4, and I think it's, as long as we have the clarification that the alternative location analysis is intended to be the same, I think it fits that. That's one of the areas where I was a little bit concerned about having the requirement in there again, because there's now kind of the new alternative location analysis in 604B4B there. And so I just wanted to make sure, I think it's clear with the suggestion that you made, the reference back, but I just wanted to make sure no one else had concerns with that, as there's kind of 2 different areas now where it talks about the alternative location analysis.
Yeah, and the place that I had put the sort of the second one was really focusing in on an ALA dealing with disproportionately impacted communities. And the suggestion I had made earlier is that the process for either of the ALAs is the same.
Okay, and I think that as long as the process is the same, I think the reference there to B4A works. I just want to make sure that, because it is specific to DI communities in the second, that there's no concerns from the other commissioners as well about that. That was my really only substantive concern there, aside from what you raised before.
I'm not seeing concerns being raised, so we will leave that as is with the clarification on the record. Commissioner Messner?
Thanks. On page 45 of 56 of the red line draft that was sent out, and I really appreciate the inclusion of the discussion around mitigation hierarchy in the previous sections, and particularly in the 300 series rules. I think that I thought that was really good, and I thought it was clear. I did have some suggestions in the third to last paragraph here that starts with the word by expanding. And again, it's talking about the mitigation hierarchy and the desegregated application of the mitigation hierarchy. And my suggestion is just a few things. There was some strike throughs of kind of the clarifying the hierarchy. So I just wanted to make sure that the hierarchy was still clear, and it is clear in different language that's utilized, but I think even repetition in this is okay. So my suggestion would be that to say, by expanding the requirements for and information necessary to perform the cumulative impacts analysis, operators will have a better opportunity to provide clear and concrete plans on how they will follow the mitigation hierarchy. That's all what's currently in there. And then I would include to first avoid adverse impacts. That first was struck through. And then I would suggest, and then to minimize those impacts that cannot be avoided. And finally, to mitigate the adverse impacts that cannot be fully avoided or minimized. That mirrors the language and the definitions and in other sections of the statement of basis and purpose, and clearly desegregates the mitigation hierarchy. And so those would be my suggestions to just clarify that. And so I can say those again if that's helpful. There's just a few additional words in there.
Commissioner Messner, I'm sorry, are you on page 45 of 56 of the SBP?
That's correct.
And you're just clarifying the first avoid point, then minimize, then mitigate in the SBP to conform it to the language that's within our rule?
Both within the rule and with other sections of the statement of basis and purpose from previous rulemakings. And so, it would just say the mitigation hierarchy to first avoid adverse impacts, and then to minimize those impacts that cannot be avoided. And finally, to mitigate the adverse impacts that cannot be fully avoided or minimized. That's the only change that I'm suggesting.
Ms. Stafford or Ms. Trask, are you comfortable that all that comports with itself and with our rules?
I think with the exception of the word fully, that comports with what we have written in the SBP.
And the fully piece I thought I pulled from somewhere else, but I could be wrong there. But I don't have to have the word fully in there. The indication is that you're mitigating the things,
right?
Because it's even a definition, but that you're mitigating the things that cannot be avoided or minimized.
All right, you good with that, Ms. Stafford?
Yes, I made those changes as Commissioner Messner was speaking.
Okay.
There's one other kind of, and I think it's just a question. And so I think this commission made a determination for timing of the director's recommendation for 14 days on OGDPs outside of a disproportionately impacted community. And then there was some conversation about inclusion in the rules of 30 days for comprehensive area plans. That was captured in, I think, Rule 306, but I'm not sure it was captured in, and I'm looking here at the rules in my notes. I'm not sure it was captured in 314G. And so unless I'm missing something, I just wanted to make sure that it was clear in both of those sections that there was the 14 and 30 days for OGDPs and caps, and then the 30 days for caps in the cap section.
Giving Ms. Stafford a chance to take a look at the rule.
Okay, so I think this is maybe why this is written or it's written the way that we put it forth in the draft here. So at least the direction as we understood it was the 30-day notice when it applies to that specific situation that's set forth in 604B2. So that would be an OGDP that includes a location that's within an approved cap that includes preliminary siting approval pursuant to Rule 314B4. So at least that language says to me the approved cap, it sort of takes it out of the cap rule at that point. We're talking, if the intent, I think, was for caps to always be 30 days, then that was not clear, at least from the direction that we received.
Maybe I'm confused I thought that we had decided that we wanted 30 days for all caps for the director's recommendation because it's such a big application and takes so much time to evaluate and to be able to provide transparency and time for people to be able to look at it. Like director's recommendations for caps generally would be 30 days, OGDP's 14 days.
No,
If I
that was not.
misunderstood the commissioner's intent, then I apologize, but I thought that's what we were talking
That was not my intent. My intent was the 30-day for a site-specific cap director's recommendation where it was within 2,000 feet of an RBU and a DIC. I was not re-litigating the director's recommendation for all caps. At least that's just one commissioner's perspective, and that's where I was moving on that.
Okay, I must have misunderstood. Other commissioners agree with that perspective, then that's the direction we gave. I think I had down in my notes that it was just 30 days for caps, in addition to the piece in the 604, but I thought it was cap wide.
Other commissioners weighing in on this point?
I was just trying to go back in my notes and see. I think my notes reflect the same as what you said, Mr. Chair. From what I'm seeing.
Commissioners Cross or Ackerman?
I'm also looking through my notes and I'm not finding any detail on that, Mr. Chair, but yeah, I don't recall.
Mine matched what you said, Mr. Chair.
Okay, I must have had a misunderstanding. So.
Well, we've been working really hard for 18 months on all these things, so getting to a final landing point is important. So, okay, other commissioners with discussion points?
At some point, Mr. Chair, I want to kind of go through and reiterate, and I don't think this is the time to do it, but at some point here this morning, the different working groups and additional stuff that we've kind of developed as part of the statement of basis and purpose, so that I think we're clear as to what working groups are anticipated and to be held, and like what the goals of those working groups are, and what needs to be included in upcoming cumulative impacts reports. And there's just a few things that are in there that I want to make sure that I understand and then we have clarity on kind of next steps.
Yep. No, I think that's a great point. I'll call upon you to lead us off on that discussion. Let's see if there's further final discussion on drafting and kind of where things are before we move to that. We might take a quick break and fill up our coffee cups and then go into that. I think I've not heard from Commissioners Oath or Ackerman, or maybe just Oath, actually. Did you have anything further?
I thought that everything that I had tracked seemed like it was represented in the updated draft. So thank you all very much for all of that hard work.
Yeah, touche. All right, well, I at least would like to fill up my coffee cup. Let's take 5 and let's return at 9:51, and then will Commissioner Messner be ready to call on you to sort of talk about working groups, and maybe Commissioner Ackerman can help with that because I know he had some influence on that as well. We'll talk about that, and then we will see where we are with next steps. See you in 4 minutes now. All right, welcome back to the Energy and Carbon Management Commission meeting. This is on docket 240600145, the cumulative impacts and enhanced systems and practices rulemaking. We've worked through the drafts that were posted yesterday afternoon, which comprise the direction from the commission to staff. Appreciate that hard work getting that back out. That, as I noted at the inception of today's meeting, was published to all stakeholders. We've got some 74 stakeholders that are listening in at this point. Commissioner Messner, I believe you had a good idea of recapturing sort of the next steps with regard to working groups, et cetera. So would like to recognize you on that front.
Sure, thanks. And I want to make sure I captured them all, so I may not have captured them all. So if anyone has anything, please let me know. And I note in the statement of basis and purpose, some of these working groups have identified potential stakeholders that could be involved with those. I would also hope that an individual commissioner would be involved with each of the working groups as well, as I think that certainly helps the process and keeps commissioners involved in those decisions as well. But my understanding right now is that, and I combine this one, and so Commissioner Ackerman, tell me if you think it needs to be 2 different working groups, but kind of a reclamation and surface disturbance working group to continue to work through some of those topics and consideration for future rulemaking or inclusion in the rules. I identified in there that there was a June 30th, 2026 update to the commission on areas of evaluation and how that's working out, and a discussion on whether or not they've been expanded or retracted, or the appropriateness of the kind of default areas of evaluation that we've adopted in these rules. The identification of a biological resources working group to further evaluate that topic and make suggestions for potential future rulemaking on that topic. A working group, an additional stakeholder work around Rule 308, Rule 311, and Rule 312. And then there was also an intent in the statement of basis and purpose that talked about that the commission intends to evaluate and update the initial list of enhanced systems and practices. And I think identifying that as something that needs to be considered by the commission. Unless I missed it, I'm not sure there was a date associated with that, but I think that could be incorporated into the annual cumulative impacts evaluation as well, or cumulative impacts report. And then what's not included in there, but I want to bring up for thoughts, is there was some conversation, and it ties again into the surface disturbance piece and the reclamation piece and some of the other conversations we had around areas of evaluation, but kind of how to better utilize the CIDR data that we've been collecting for a number of years now and will continue to collect, and how to continue to refine how that data could be utilized in bigger database sets to help evaluate and address cumulative impacts and help the commission in their decision-making processes. And so it seems worthy to have that as a topic for a working group or further stakeholder work. And then finally on my list is the consideration of a process working group to further look at and refine the application review process, the director's recommendation, and the decision processes, the decision steps as it works through the review process. And so those are what I have. I don't know if I missed anything.
Others with thoughts? Commissioner Ackerman?
Thanks. I don't have anything that you missed there, Commissioner Messner, and appreciate you bringing this up. And I think it's a good idea to, if not today, at some point identify commissioners that potentially not necessarily coordinate, but participate with those groups. And I agree. My notes that I have and that I've been discussing with Interim Director Ray pending the conclusion of these hearings are two responsibilities, and that's the reconvened biological resources issue. And I think staff did a good job of capturing in the statement of basis and purpose the goals that were set forth by the commission there. And they stated to evaluate additional regulatory changes, including but not limited to the necessity and feasibility of a separate rule series focused on the protection of biological resources. And then they also included some specific inclusions of who might be involved in that group. I hope that we would have an opportunity to continue to consider that and involve additional folks as necessary as well. I also have a note that we talked about professional facilitation for this group, and a note to talk to Interim Director Ray about beginning the procurement process as soon as we can after these hearings, as well as discussing who the staff contacts might be. With regard to the other point that you raised that I would suggest that I be involved in is the surface disturbance issue. And I agree with Commissioner Messner that I think we can wrap a lot of this in, although I want to put a pin in the cider issue. This is related to that as well. That may be potentially a separate but related group, the way that I see it. And the additional or the kind of the initial goals that I think we've somewhat set forth in these hearings, and I've been talking with Interim Director Ray about a little bit, are to one, map oil and gas disturbance and disturbance types as real time as possible. So that's one of the goals for that group to talk about. Another would be to evaluate other surface disturbance maps of value for inclusion in our online GIS tool. And then together with that, I have, as you stated, Commissioner Messner, considering additional metrics on this front for inclusion in the annual cumulative impacts report. And then I have certainly some notes about potential procedure and process there as well. But those, as I see it, are the goals for those two groups. And my intent is to initiate processes on those shortly after these hearings conclude.
That all sounds good, Commissioner Ackerman. To me as one commissioner, maybe what I suggest is let's finalize where we're going today. Let's put a pen in it to get back, after we've all had a chance to sort of read where we ended up and note the areas that we need to be moving forward on. And then let's create a working session at some point in the next few weeks. And then at that point, we can, revisit these additional next steps and make assignments out to commissioners to help facilitate working with our subject matter experts at staff on each of these important topics. I think I've written down like 6 of them, and I'll keep a note on that. And then we can try to sort of define out the scope of how we're going to be moving forward. And I don't know that, I guess what I'm saying is I don't know we need to make finite determinations this morning. Let's get through the rulemaking, and then let's come back and at a quiet time when we're all rested, we can generate out assignments, etc. But good job capturing the points of necessary work, additional work moving forward. And as I pointed out at, I think, the last hearing, cumulative impacts is absolutely not a static piece for us, and we'll continue to work forward on all of these topics as we move forward with the work that we do. AG Davenport, I see you visualized. Did you want to bring something to the table?
Thanks, Chair. I don't have any suggestions or changes. I just a point of clarification for my own edification. Are these working groups going into the SBP, or is this just a discussion of working groups and potential process going forward?
I don't know that I felt like it needs to go into the SBP. The SBP is a clarification of the rule that we're adopting. These are just additional steps that we think are absolutely necessary and pivotal to moving this whole dialogue forward on a number of different steps. We've made some initial determinations on biological resources today, or we will have made. The 308, 311, 312 has landed in a spot, but it needs additional work, as noted by the commissioners. We have a statutory duty to continuously ensure that we are evolving the enhanced systems and practices. I don't know. It's just my musings on that topic.
So, Mr. Chair, some of these are in the statement of basis and purpose. I pulled them out of the statement of basis and purpose. So the only ones that aren't arguably are the process working group and the CIDR database working group. The rest are all pulled directly from the draft statement of basis and purpose.
Okay, great. I don't have a problem with that. Either way is fine with me. I didn't go back and peruse through it as tightly. AG Stafford, are you in agreement with Commissioner Messner's statement there?
I am, Chair Robbins. I think, at least as it relates to the reclamation and surface disturbance data, there is some language in there about an intent to continue investigating ways that we can develop and refine that information gathering process, but we don't specifically have like that working group language built in there. But the intent is at least there.
Anybody with concerns about that?
If I may make a suggestion,
Go ahead.
perhaps the SBP can simply note that the commission had a discussion about working groups and not changing the substance of what's in the working group, but also note that the commission did indicate an intent to have more than just what's listed in the SBP potentially. And that way, obviously after this rulemaking is complete, the SBP is not going to change. And so I want to leave the commission with the discretion to change those working groups or add to those working groups without having to worry about going back and modifying an SBP.
That's fine with me. Anybody have concerns?
AG Stafford, does that work for you?
Thank you, AAG Davenport. Just to clarify, this is more of a general reference that the commission intends to convene several working groups. So would that involve moving around the different references that we currently have, or simply leaving what we have as is and making this general statement somewhere up in the SBP?
My thought was the latter, just not making any real substantive changes, moving things around in the SBP, just adding a general statement acknowledging that the commission had these discussions. These are examples of some of the working groups the commission intended to convene, but that there may be more, or the working groups may change as we get into them.
Thank you. I understand now.
Okay. And I'm not a commissioner, obviously. So if any commissioner has a problem with that.
Seeing commissioners nodding affirmatively. So,
'Thanks.
directed. Other last thoughts? Ms. Trask, anything further?
No, Chair, I don't have anything specific today.
We then move to deliberations. Any commissioner want to lead off in deliberations?
I'm happy to start, Mr. Chair. And I really appreciate the work that's been done on this. You know, this is a process that has been worked on for a really long time, and with lots of thought, lots of work, lots of input, lots of out of the box thinking, and lots of different people, really trying hard to come up with ways to evaluate and address cumulative impacts. This is an incredibly difficult topic, and the fact that we're taking such strong steps towards continuing to evaluate and address cumulative impacts, I think says a lot about the intent of the ECMC and how we're approaching the work that we're doing. In any rulemaking process, there are things that I may think that are important that don't always get incorporated into the rules. That's okay. This is a 5-member commission, and I acknowledge that there is, on purpose, different perspectives, different thoughts, different backgrounds, and different opinions on how we ultimately land on rules that evaluate and address cumulative impacts. And I respect each of my fellow commissioners, in their perspectives and in their process to ultimately accomplish these rules. I think that there's a lot of good things that these rules do accomplish. I really appreciate that, again, we're trying to address biological resources, which is also a really challenging topic. I think we've taken another big step forward here. I remember from the mission change rulemaking, the topic of biological resources being a really challenging topic. I think that we didn't follow through with some of the rulemaking or steps that we had hoped to follow through with between the mission change rulemaking and this rulemaking. But I think this rulemaking does take another strong step forward with a plan to develop a further working group to evaluate the additional regulatory changes and the potential for further rulemakings on this topic, which I know that we will convene that and take those steps forward. I really think it's great that we've developed the community liaison role to facilitate communication and engagement with residents of disproportionately impacted communities that have often faced unique challenges with engaging in processes before this commission, with the goals of building trust and transparency, providing meaningful opportunities to influence public policy, and modify proposed state action in response to public input to decrease environmental burdens or increase environmental benefits. I think it's a really strong step that's been taken on the community liaisons piece. I appreciate that we're really striving for proper application of the mitigation hierarchy to the OGDP and CAP application and review processes. And in the evaluating and addressing of direct, indirect, and cumulative adverse impacts, I think that everyone acknowledges and understands that that includes first avoiding impacts, then minimizing those impacts that cannot be avoided, and finally mitigating the impacts that are not avoided or minimized. And so appreciate the inclusion of that in the rules, and appreciate the inclusion of that in the statement of basis and purpose. I think carries on the intent of SB 19-181 and our mission change rules, and look forward to continuing to have detail on that in future rulemakings as we get to the relevant sections. I think it's a strong step to include a pre-application and post-completeness community meeting. I think it provides transparency and aids towards meaningful community engagement and input in the OGDP and CAP application processes. I appreciate that we're continuing to memorialize and support local government's authority to regulate oil and gas development within their jurisdictions, and with the ability to influence decisions for the proximate local governments, with co-equal regulatory authority with the relevant local governments, between state and the local government review processes, and that we continue to strive for coordination with the local government in reviewing of applications. I appreciate that we're expanding notice distances, review timelines, and opportunities for engagements in the application process for both communities that disproportionately impacted communities, as well as residents that are not in disproportionately impacted community. And many times that includes a half mile for residents and building units outside of a disproportionately impacted community, and 4,000 feet for building units within a disproportionately impacted community, with the expansion of 14 days for the director's recommendation inside disproportionate or outside disproportionately impacted community, and 30 days within disproportionately impacted community to allow for additional time for review and input from community. I think that we've taken strong steps towards clarity and expansion in the utilization of alternative location analysis, with the understanding of how it will be utilized as a tool for proper implementation of the mitigation hierarchy and used to evaluate and address cumulative impact. I appreciate the strong initial steps here towards the enhanced requirements and expectations for community outreach plans as part of OGDP and CAP applications, to facilitate improved outreach and ongoing transparent communications with residents in proximity to proposed operations. I think we've also minimized the utilization of lesser impact area exemptions, which I think was a good step. I think we made important clarifications to Rule 308, identifying what additional information can be requested by the Commission in Form 2 applications to ensure protection of public health, safety, welfare, the environment, and wildlife resources. I think we've made clarification and updating of cumulative impact information necessary in CAP applications to ensure that cumulative impacts are evaluated and addressed, and information is captured in the CIDR database. I think now there's a clear requirement for the submittal of a cumulative impacts analysis and the associated submittal requirements and plans that impel the applicant to critically evaluate how the proposed operations incrementally affect cumulative impacts, and clearly lays out how an applicant will evaluate and address those cumulative impacts by proper application of the mitigation hierarchy, and it's not a check the box exercise, but a critical and thorough evaluation and application of the rules. It also ensures that both the director and the commissioners critically evaluate the implementation of the mitigation hierarchy in their review of OGDP and CAP applications. The rules also implement the ECMC regulatory process requirements for adherence with the CPHC NOx and greenhouse gas intensity standards to ensure compliance, and I appreciate the additional protections that includes. And I think that there's also inclusion of a number of other protections and processes for applications within disproportionately impacted communities that are in proximity to people that I appreciate as well. And so I think we've taken a big step forward with these rules. I think that there's still work to be done, and I think there's still learning that can occur as we implement these rules and look at further working groups and further conversations about how to properly address and evaluate cumulative impacts in the state. But do want to say that I'm proud of the work of the stakeholders, of the community, and of the commission staff for the steps that we've taken over the last couple of weeks. So those are my deliberative thoughts here.
Thank you, Commissioner Messner, for leading us off with positive, deliberative thoughts and articulations. Others desiring to weigh in on deliberations? Commissioner Ackerman?
Thank you, Mr. Chair. I appreciate Commissioner Messner's summary and couldn't have said it better. My wrap-up comments are very brief. I just wanted to state that I really appreciate the work done by staff and recognize your comment earlier that this has been an enormous lift for staff and the Attorney General's office throughout this year, and particularly during these hearings and the processes leading up to the hearing. This process really illustrated why I'm very grateful to have a professional commission with specific significant areas of expertise. I always find that structure helpful, but I particularly found it helpful during these hearings and appreciate the expertise of my fellow commissioners. As I go about my everyday life, it's rare that I'm not pondering some aspect of the work we're doing here, and particularly the aspect of the work that falls within my areas of expertise. And like Commissioner Messner stated, well, as the commissioner who sits in the Wildlife, Environment, and Reclamation seat, I really am excited about the progress we're making through these rules and the prospect of continuing to make strides, particularly towards protecting Colorado's natural resources and ecological systems. I also wanted to recognize that I think we had an all-star cast of participants in these hearings. I don't want to mention specific names for fear of leaving someone out, but there are many individuals from different walks of life that really dedicated significant portions of this year to work towards the betterment of Colorado for all Coloradans that will likely largely go unnoticed by the majority of Coloradans, but certainly doesn't go unnoticed by me. And I think there are a number of people that should be very proud of their participation and that many of their ideas and their requests have been implemented in these regulations and may not have been without their participation and their vocal expression of their ideas. So I just wanted to say a broad thank you to those who participated and look forward to continuing to work together. Thanks, Mr. Chair.
Thank you, Commissioner Ackerman. Appreciate those thoughts as well. Commissioner Cross?
Thank you, Mr. Chair, and thank you, Commissioner Messner and Commissioner Ackerman for leading off this discussion. I will be brief and second the praise that was given. Our staff was amazing during this. For the stakeholders, this process has been going on since the beginning of 2023, and I think that it's gone through a lot of ups and downs and changes, some directed by the legislature, some directed by the commission, and I'm very happy with where we've ended up. As has been said repeatedly, we have the toughest regulations in the country on oil and gas, and I'm proud of those regulations. I'm proud of stakeholders participating and making sure that we're doing our best to make sure that we regulate in a manner that's protective of public health, welfare, safety, wildlife, and environment resources. I'm proud of industry for continuing to work within these difficult regulations and show the rest of the country that despite difficult regulations, we can continue to thrive as an oil and gas producing state. With respect to this rulemaking, I'm also want to say thank you to the stakeholders for working together. Not only did we get a lot of participation and a lot of great comments and suggestions and ideas, but I appreciate the time that was taken off in some of the breaks from these hearings and groups getting together and talking and trying to come up with ideas about how stakeholders can come up with a common ground of how we can move forward with these regulations. And so I'm also appreciative of that. And given that a lot of my comments have already been addressed with respect to the specific rules, I'll again just keep it brief, but I want to give my thanks to staff, give my thanks to shareholders, and give my thanks to my fellow commissioners for the hard work done over the last month.
Thank you, Commissioner Cross. Commissioner Oath?
Thanks, Mr. Chair. I will just echo all of the comments that have been made by other commissioners so far. Just huge thanks to everyone who participated in this process. I think where we have ended is much improved from certainly where we started, and that's thanks to all of the perspectives of of everyone who engaged in the process, and that means a lot. I think many of the elements of the rule have already been summarized and highlighted, so thank you to my fellow commissioners for doing that. I mean, many things about this rule stick out to me, but maybe just to highlight two areas, one being addressing cumulative impacts in a really meaningful way. I think that these rules together, and the processes that we will be engaging in going forward are a huge step in that direction. So I am really looking forward to implementing these new processes and addressing cumulative impacts going forward. I also feel really good about where we landed with respect to, ensuring that we are engaging in a really proactive and prospective way, and ensuring that we will comply with the state's air quality goals in a way that is meaningful and not duplicative. I'm looking forward to seeing that implemented as well. So again, thanks to all of you. It's been a joy for this to be one of my first rulemaking hearings, a big lift, but it certainly was incredibly helpful, as Commissioner Ackerman said, to have various commissioners with differing expertise to bring to the table, in addition to our wonderful staff and all of the parties to the rulemaking hearing. So that is all I have to share. Thanks.
Thank you. Thank you to my fellow commissioners. I've got some thoughts, but I would like to make a motion first. I would move that we approve docket 240600145, say it for the last time, the cumulative impacts and enhanced systems and practices rulemaking as generated by our staff yesterday, with the opportunity for staff to make conforming typographical errors in one last read through. AAG Davenport. Does that motion suffice?
I believe it does, Chair. The only change that I would make, I think, is just to clarify that what the well, a couple of things. What the motion is to approve the draft released yesterday, October 14th, with changes made by the commission in the course of deliberations today, and the SBP as well. And finally, that I just want to make sure that you're authorizing staff to make typographical corrections and other conforming corrections as well. I missed that part of your motion, but I just want to clarify that.
Motion is so clarified by AAG Davenport.
Second.
Motion and a second.
Third.
Do we have a fourth and a fifth? No, I appreciate it. All those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. With that, would like to just echo the points made by my fellow commissioners. I think that it's important for Colorado to recognize that we have a unanimous vote on these rules. It's been a significant undertaking. Want to clarify the thanks to staff and to all of our stakeholders. This has been a Herculean effort. The fact that we've gotten to a good spot, we have the most protective oil and gas regulations in the nation, and this rulemaking builds on that foundation and puts into place even stronger protections for Colorado families, and sets a new and higher standard for evaluating and addressing the cumulative impacts of oil and gas operations, especially for those within disproportionately impacted communities, which was not part of the title of the rulemaking, but was definitely an important point that we've made here. So I think that this is an important next step, and I really look forward to the next steps, which is implementing these rules and working together with our stakeholders as we move forward with the rulemaking that we put into place. Anything further? Thanks, folks. Thanks to the 71 folks that are continuing to participate with us. We really appreciate it. We could not have done it without you. We reconvene tomorrow morning for our normal business agenda. We'll see everybody then.